I'm Susan Stark. I'm the Director of Program for the League of Women Voters of Denver. An overarching mission of the League of Women Voters is to defend democracy. To accomplish this, one of our main actions is to provide voter and democracy education, and that's why we're here tonight. At the 2024 convention of the League of Women Voters of the U.S., delegates voted to proceed with an intensive and well-researched one-year study on the federal judicial system. This study is to be completed on a fast-track timeline so that a position can be announced at the League of Women Voters of U.S.'s 2025 Council this June. LEAD uses a process of consensus of all of its members nationwide to establish formal League positions. We also have state and local positions. League advocates for legislative changes at all levels of government, sometimes in favor or in opposition to legislative proposals. However, our legislative action committees cannot do this unless we have a League position related to the legislation. While nationally, League holds a principle that, quote, governmental power should be exercised with the constitutional framework of a balance of three branches of government. After polling its more than 700 local leagues around the nation, League of Women Voters U.S. found no position statements pertaining specifically to the federal judicial branch. So a national study group of League's legal experts set out to do in-depth research to provide all local leagues with a proposed position about which our members could arrive at consensus. The meetings at which Denver members will hold consensus discussions will be at the end of March. When we on the Denver League's program committee learned that in the spring of 2025, we would be holding these consensus discussions, we decided it would be useful to provide a basic civics-style class about this powerful third branch of government. How many of us remember much from our high school civics class about the federal courts? I certainly didn't. A study group was formed at the end of last summer to develop tonight's program, which we entitled Our Federal Judicial System 101, with the goal of providing a basic knowledge and context for League members' consensus discussions and a refresher class for the community. Of course, some of the impetus for the League of Women Voters U.S. to go this route has been the widely covered legal decisions of the Supreme Court in recent years. Both its ground-shaking decisions such as Dobbs, which overturned a 50-year precedent, and the deeply scrutinized selection of the three newest justices, as well as the personal actions of certain of our court members, all of this has spurred us who care about democracy to take a closer look at what has been called the most powerful court in the world. So that brings me back to tonight's presentation. This will be both fast-paced and intense. In the next hour or so, we are going to show you what the current federal court system looks like, the origins of the courts going back to Article 3 of the Constitution, a compacted history of the seminal cases and evolution that carved out the structure and process of today's Supreme Court, the major problems facing both the lower federal courts and the Supreme Court, and finally, some of the suggested reforms to address these problems. Whew. Fasten your seatbelts, folks. At the end of tonight, we don't expect this to be etched in your memories. All of the slides we put up, the working papers of our study group, and the comprehensive list of all the resources we consulted are currently, I think by now, posted on our website at LWV Denver. And within 2 days, the recording of tonight's event will also be accessible at that website. We will have a Q&A after the presentations. Please feel free to put your questions in the chat. The chat will be monitored by Pearl Ann Zillarni, our co-director of communications, who will pose your questions to the presenters. Your audio will be muted during the presentations, but if there is time at the end, after we deal with all of the chat questions, we will unmute and you can ask questions verbally. Please know that we may not be able to answer specific legal questions. Only one of our study group is a lawyer, Bob Connolly. Also, please keep in mind that our goal is to give you an overview. Those of you who want to dig deeper can make use of our list of resource materials. So let's get started. How did we get to today's federal court structure? While writing the U.S. Constitution, the Founding Fathers wrestled over how to handle the problems of the 13 states trying to come together as one country. Each state had its own court system, and there was no consistent way to resolve conflicts among them. In addition, there was no way to redress a wrong perpetrated by a state against a citizen or one state against another, or to adjudicate issues arising from such areas as maritime commerce and foreign relations. James Madison joined other founders to propose a new constitution with 3 branches of government to exercise checks and balances, each on the other. They viewed the judiciary as the weakest branch. In addition to the already existing state courts, the Constitution in Article 3 provided for the creation of 1 Supreme Court and such inferior courts as the Congress shall from time to time ordain and establish. Thus, from its beginning, the judicial system was to some extent under the control of the legislative branch. Early on, the executive branch was also given power over the judicial branch. In Article 2, Section 2, it states, quote, "The president shall have power by and with the advice and consent of the Senate to appoint judges of the Supreme Court, but the Congress may, by law, vest the appointment of such inferior officers in the president alone and in the courts of law." The lifetime tenure that federal judges and justices have today was not written into the Constitution. Rather, the language settled on by the founders was that they, quote, "shall hold their offices during good behavior," which was also not specified. Ironically, as it relates to today's federal judiciary, the founders argued that because the courts did not have the enforcement power, like the executive branch, or the financing power of the legislature, they were unlikely to offend against the liberties of the citizens. Some present-day legal scholars intended to have argued that good behavior clause means that justices were intended to have lifelong tenure. But that is not true of all interpretations of the Constitution. In 1789, the Judiciary Act created 1 trial-level district court in each state, plus Kentucky and Maine, which were not at the time yet states, with circuit courts of appeal above them. The Supreme Court justices were each assigned to a circuit, and they were required to ride around by horse, as the circuit court judges did in Britain. By 1890, with the significant growth of the population, the increased numbers of states, and the passage of amendments beyond the first 10, the Supreme Court had far more cases than it could handle. Thus, the Judiciary Act of 1891 created 9 circuit courts empowered to hear appeals that had, up to that time, come before the Supreme Court. In addition, this act gave the Supreme Court more power to choose the cases that it felt were worthy of its time. Supreme Court justices no longer had to ride circuit, but remained supervisors of 1 or more of the circuit courts, a reform that substantially increased the Supreme Court power. As the U.S. population grew and changed, where it was most dense and thus where the most cases arose, the numbers of circuit and district courts increased and shifted. For example, a circuit court of appeals was created for the D.C. area in 1893. And more recently, in 1980, the 11th Circuit was created as it split off from the 5th Circuit. The creation of these 2 circuit courts found in the deeply conservative south of the country, that's the 5th and the 11th Circuit, has had major impacts on where some of the most controversial and nationally impactful cases have arisen in recent years. I now want to hand off to Bonnie Clark, our next speaker, who will cover the current structure of the federal court system. Bonnie, unmute yourself, please.
Sorry about that, folks. The slide that's up now shows you the structure of the federal courts today. We're going to be focusing on the left side of the slide, particularly at the lower level. But this does show several of the more specialized courts, which it's interesting to know are there. So we now have a district court, at least one district court in each state. Some states have more, and they're divided up into geographic areas that may be denoted the northern district of the district court of the northern district of California, for instance, or the western district of Texas. There are 94 all told. Some of those very busy districts have divisions, and some of those divisions have just one judge assigned to hear the cases there. This will get mentioned later in the problems section. Altogether, there are 673 authorized district court judges. In January of this year, there were 37 vacancies, and the oldest vacancies dated back to November 2021 in Mississippi and Arkansas. Nearly every federal case will start. Can we go back to the green slide, please? At the district, one more, thanks. At the district court level. And all trials are held at the district court level. The most distant of the district courts may be the one in the Mariana Islands. Since it's a U.S. territory, it is subject to U.S. law, and it must have a federal court. For those of us in Colorado, most of us, some interesting cases that have occurred in Colorado are the United States versus Nicholas and McVeigh. That was tried here because it was moved from Oklahoma. It's the Oklahoma bombing case. The Republican River case, which was Kansas versus Nebraska and Colorado. This did not begin in Colorado. Since it was state against state, it began directly at the U.S. Supreme Court. It was filed in 1998, wasn't decided until 2015. There were several proceedings, factual proceedings, held under special masters during that long process. And a recent case of note was Masterpiece Cake Shop versus the Colorado Civil Rights Commission, which dealt with the constitutionality of the civil rights action and matters of religious expression. So back to our chart again. Above the district courts are the circuit courts of appeal. And there are altogether 13 of them. 12 of them are geographic, and you might have noticed that there's no number 12 on the map slide, but that's just because there wasn't room, presumably, to stick it in there. It handles the District of Columbia. There is also a federal circuit court of appeals, which is the only one that's not defined by geography, but instead by the types of matters that it handles. Altogether in the circuit courts, we have 179 judges authorized. There were 3 vacancies in January of this year. As I said, they handle matters that are appealed from the district court. They review the reasoning of the lower court, but they have to work with the facts that were set out in the record of the district court, which is where the trial was held. And finally, up in the rosy maroon color, we have the Supreme Court of the United States. There's only one of them. It has 9 justices. We have no vacancies. It takes place in, in one courtroom, has just 50 seats for observers, and there is no television or any other video recording permitted. In Colorado, we have 9 district court judges, 8 district court judges, pardon me, 9 senior judges, and trials are held in 5 courthouses, 2 of them in Denver, 1 in Colorado Springs, 1 in Grand Junction, 1 in Durango. And as the map has shown you, we are part of the 10th Circuit Court of Appeals. Now, Bob Connolly is going to tell us more about what the Supreme Court has been up to over its many years.
All right. My name is Bob Connolly. I'm a retired attorney. I'm going to provide you with a very high-level summary of the substantive divisions, the ebbs and flows of the Supreme Court over its 2¼ centuries of existence. I'm going to use 8 or 9 slides. For those of you wishing more detail, the website contains a document called the Short History of the Supreme Court. For those of you looking for a natural sleep aid, there's a 5-page document with citations to various sources that we've been using to compile our presentation. I'm going to start with the early cases, and while I graduated from law school 50 years ago, I don't go quite so far back as these cases. The first case is a case called Marbury versus Madison. It's still cited to this day. It established what must seem like a self-evident proposition to all of us, but at the time, the federal court system was very, very new, and so this case established that federal courts could declare statutes and actions as being violative of the federal Constitution. The remaining 3 cases aren't quite so noble. The Dred Scott case ruled that the federal government could not abolish slavery. That took the 13th Amendment in 1865. U.S. versus Cruikshank essentially ended Reconstruction and ushered in the Jim Crow era by severely limiting the Equal Protection Clause of the 14th Amendment passed in 1865. And then Plessy versus Ferguson was the case that said you could segregate white and black children in schools, but so long as the schools were, and I use air quotes, equal. Next slide, please. I'm skipping over a lot here, but the latter part of the 19th century into the 1930s, was characterized generally by a very conservative court that was interested in protecting property rights, the rights of employers and institutions over the rights of individuals and employees, and was based, according to lots of observers, on a fear of socialism and redistribution of wealth by the government.
It's here.
Hello. Hello. Okay. Next slide. Development of the modern court. Most people date this from the Judiciary Act of 1925. Sue mentioned the Judiciary Act of 1891, which established circuit courts and gave the Supreme Court some discretion on the cases that it wanted to hear, but they were still hearing far too many cases, at least according to former President William Howard Taft. He of the stuck in the bathtub story, and he wanted to have the court have total discretion on the cases it heard, and that it should only be hearing cases of great consequence. In fact, transcended is misspelled there. I thought we corrected it. But anyway, it reduced the Supreme Court's caseload and the procedural vehicle, which had been established in 1891, was writ of certiorari, where parties who did not prevail in the lower courts would petition the court for issuance of a writ of certiorari. If that was granted, there would be briefing, oral argument. If not, that was the end of the case, by and large. Next slide, please. Most of you, I'm sure, have heard of the court packing scheme, which was never implemented, but Roosevelt, FDR, was elected in 1932, and while some of the New Deal legislation was originally upheld by the Supreme Court, as time went on, the Supreme Court kept striking down New Deal legislation under the Lochner rationales that people were being, employers and institutions were being denied their rights to enter into contracts, and therefore their liberty was somehow constrained. After Roosevelt's landslide election in 1936, and it was a landslide, the Electoral College was 523-8, Senate was 74-17, and the House was 334-88. In any event, New Dealers and Roosevelt thought about increasing, which we'll talk about later, Congress could do, increasing the number of justices to up to a maximum of 15, which would dilute the majority conservatives who were overruling New Deal legislation. But it became unnecessary because some of the more conservative justices changed their tunes. And then between 1937 and 1941, Roosevelt had 7 appointments to the Supreme Court. Next slide, please. World War II and the McCarthy era, the Supreme Court didn't cover itself in glory, at least in the Korematsu case, which was decided in 1944, which said it was constitutional to force Japanese Americans into internment camps during World War II, even if it wouldn't have been constitutional if there hadn't been a war. The steel seizure case arose during the Korean War, where Truman tried to nationalize the steel industry because of threatened strikes by steel workers, which would have impaired the war material preparation. And the Supreme Court said that was beyond his war powers under the Constitution. And then most of the McCarthy era laws that subordinated individual rights to national security were upheld by the Supreme Court. Next slide. Probably the case that most people know best is Brown versus Board of Education in 1954. It expressly overruled a separate but equal decision in Plessy versus Ferguson. It was a majority or a unanimous decision. That said, there was really not that much. There was some sporadic desegregation and equal rights litigation and efforts, but there wasn't much for 10 years until Johnson was president. The Civil Rights Act of 1964 and the Voting Rights Act of 1965 were passed. Next slide, please. It's called the liberal era. Most people call it the Warren Court. From the late 50s to the early 70s, the composition of the court changed. with the appointments of liberal members and the retirements, deaths of conservatives. We'll see a pattern here where the tenor and trajectory of the Supreme Court's decision are subject to some serendipity. So who gets to appoint whom to the Supreme Court? Are they conservative, liberal, or somewhere in the middle? For the Warren Court, free speech, separation of church and state, rights of criminal defendants, individual privacy rights. Probably the two most important cases there were Griswold dealing with the right to advertise and purchase birth control, and then spun off from that was the famous Roe versus Wade decision in 1973. Next slide, please. The court began to drift to the right in 1969 when Nixon was elected, and continued to drift to the right until the early 90s. Again, it was largely a function of the fact that 10 appointments during this period were made by Republican presidents. Many conservatives saw this as an opportune time to overturn key decisions by the Warren Court. And while some of those were eroded or constrained, none was explicitly overruled. Next case, next slide. The path to conservative supermajority, some people debate when that began. From my perspective, and by this time I was practicing law, it began in the late 80s, and I would say with the rejection by the Senate of Robert Bork, a very conservative University of Colorado, University of Chicago professor as a nominee to the Supreme Court. In the early 1980s, the Federalist Society, which I think most of us have heard about, was established. And after the Bork decision, conservatives were bound and determined not to let that happen again and try to reverse the way that decision came out. And it was aided and abetted by the fact that liberal or moderate justices retired or died and were replaced by conservative. Next slide, please. I'm going to jump to key decisions of the current conservative court. I call current court both the Rehnquist court before he retired and the Roberts court. The most important case in a lot of people's minds was the express overruling of Roe versus Wade. Gun rights were expanded. The Heller case established a personal right to keep and bear arms individually. Barriers between church and state were reduced and continue to be reduced. Limits on the amount of money spent on elections were virtually eliminated by the Citizens United case. Barriers to government regulation of private industry were erected. It's a fairly technical decision, but the recent Chevron overruling by the Supreme Court, probably most emblematic of it. And there was actually a decision today by the Supreme Court that said the EPA had overstepped its authority in promulgating certain regulations. Probably the most, some people's mind, the most infamous decision was the grant of presidential immunity in the Trump versus US case, unprecedented case. Some would say, but again, I won't editorialize, that it was created out of whole cloth. And then the use of the what we call the shadow docket, where applications for emergency relief are made to the Supreme Court rather than the usual certiorari procedure, and the Supreme Court is asked to rule quickly because of the urgency of the nature of the decision below. And that has been increasingly done with often no indication of the reasoning behind the decisions, or even how the justices voted. The most recent case was the end of last week, when the USAID lawsuit that where the lower court, both the circuit court and the district court, said that the executive had to restart funding of $2 billion in foreign aid, and the administration ran to the Supreme Court, and Chief Justice Roberts stayed that the ruling of the two lower courts and asked for further briefing. And I checked just before we went on the air, and there hasn't been a decision on that yet. So that's all I've got. Hope I haven't overstayed my welcome. Thanks.
Thanks, Bob. We're now going to turn to some of the problems that are faced in the lower courts. That would be on this slide in the blue, the courts of appeals and the district courts. I'm going to deal with some of the problems and the recommended reforms of those problems. And then after I speak, Heather Shannon is going to address the problems and the suggested reforms of the Supreme Court. The first one I'm going to talk about is something called judge and forum shopping. Next slide, please. Judge shopping is defined as a tactic to steer cases that challenge government policies to sympathetic judges, at times in small courthouses where only one or two judges preside. The San Antonio District Court, where Judge Matthew Kazmierek presides, has been selected several times to hear reproductive rights cases, for example. Often these are high-profile cases with national impact possible. Forum shopping seeks to find a particularly conservative or liberal circuit court of appeals to hear a case in an attempt to get a nationwide injunction by a judge who is partial to a particular political party stance. With regard to the federal court forum shopping problem, an injunction would often take the form of an appeals court judge ordering a person or a state to do or to cease doing a specific action that was decided at the district court level. These are often injunctions against policy, not just to protect a certain plaintiff, and can have a wide impact across many states. Politicization of the judiciary has meant that judges who are cherry-picked in this way by a particular side in a major case might not be relied upon to remove themselves from a case despite their own personal biases. Suggested reforms to this problem are: in March of 2024, the Judicial Conference, the judiciary's top policymaking body, announced a new policy to promote random case assignment throughout a federal district, not the smaller division in which it was first filed, to combat forum shopping and its derivative, judge shopping. This proposal is only under consideration at this time. Another suggestion from the American Bar Association is a resolution urging federal courts to eliminate case assignment procedures that, quote, predictably assign cases to a district judge without random assignment. When an injunction is contemplated in a case of nationwide impact, and when one of the parties raises concerns about the case assignment. Other reforms have been suggested as well. A second area of problems in the circuit and district courts is how judges are appointed and how vacancies are filled. It may surprise you that the U.S. Constitution sets forth no specific requirements about who can become a federal judge. They are not required to hold a law degree, to have tried cases, or to have argued a motion in a state or federal district court, despite the possibility that they carry a lifetime appointment. The American Bar Association's Committee on the Federal Judiciary reviews each candidate's integrity, competence, temperament, and experience, issuing a rating of well qualified, qualified, or not qualified. But this ABA endorsement system is not necessary for confirmation. Another problem is the blue slip process. By tradition, after the president nominates a candidate, a blue form is given to both the senators from that candidate's home state. This blue slip process allows a senator to approve or disapprove or withhold a decision about a candidate. If a candidate gets just one disapproval, they are withdrawn, or if a blue slip is not turned in, the process may be delayed indefinitely. This process is open to a range of subjective responses having nothing to do with a candidate's qualifications. Moreover, blue slips have dangerously slowed down the filling of vacancies, as in Florida, where some were left open for over 700 days. Suggested reforms include a constitutional amendment, which would be needed to be passed to establish requirements for being nominated as a federal judge. However, Congress could pass legislation setting specific qualifications for nominees that the president would then need to consider. In either case, bipartisan support would need to be required, and the Senate Judiciary Committee could still exert subjective or partisan judgment. There have also been calls to abolish outright the blue slip procedure. In fact, Republicans temporarily eliminated this process for appellate judge appointments during Trump's first administration. A third problem area is that there are not enough judges to hear an increasing number of cases. Prior to 2024, Congress had not passed any comprehensive legislation to address the capacity of federal district courts since 1990. No new judgeships had been authorized in the federal court system in over 30 years, even though prior to 1990, federal courts were expanded 10 times. Our population and the resulting number of federal litigation filings have grown rapidly in the last 20 years, increasing by 20% over that time. Yet the number of judges has remained static. This leads to long delays in judgments, and as the saying goes, justice delayed is justice denied. The sharp increase in executive orders and challenges to them adds to the overload. As of March 2024, the number of pending civil cases in federal courts rose to 80,000, a 346% increase. And since January 20th, I believe the last count is that there have been 74 cases already brought to address the executive orders that are coming out of the current administration. The proposed reforms include, in August of 2024, the Senate passed the Judicial Understaffing, Delays, Getting Emergencies Solved, or Judges Act. That's a mouthful. But the House held the bill up until mid-December after the November election to ensure that the Democratic administration could not use it to appoint much-needed judges. Then Biden vetoed the bill in late December. Thus, a potential fix for the problem of too few federal judges fell to political pressures. A fourth area of problems is the lack of diversity on the federal judicial bench. As you can see from this slide, gender and racial composition are significantly out of balance among federal judges. But other factors such as socioeconomic background, educational history, and professional legal experience can also influence decision-making, even if judges profess that the knowledge of and fidelity to the law are the bases for their decisions. At a time when trust in the fairness, impartiality, and ethics of the judicial branch is low, the selection of new judges should better mirror the American population. The first Trump administration and the Biden administration displayed starkly different ways of increasing or not increasing the diversity of appointments. Problems certainly remain given the push against DEI now. Proposed reforms include Congress could again take up the issue of increasing the number of Article 3 judgeships. And though it is highly unlikely in this political climate, Congress could put forth legislation that requires diversity to be a strong consideration in the process. A fifth area, and the last one that I'll talk about, is accountability and enforcement of the Judicial Code of Ethics. The slide you have before you, and again, this will be on our website, so you don't have to read through all of these, but this puts forth what they call the canons that the lower court, Article 3 judges are pledged to follow, and the Supreme Court is not pledged to follow. A link, as I said, to this code of ethics is at our website. Alleged violations can be the basis for review of judge misconduct under the Judicial Conduct and Disability Act. However, problems arise due to the policing of violations, accountability, and enforcement. Of special note and related to the lack of diversity of federal judges is that federal judges are generally not considered subject to Title VII protections when it comes to their employees and clerks, meaning that the people working in the federal judiciary are largely exempt from the protections of this part, Title VII, of the 1964 Civil Rights Act, which prohibits discrimination in employment based on race, color, religion, sex, or national origin. This leaves federal judiciary employees significantly fewer protections against workplace harassment and discrimination compared to other employees. In addition, federal judges oversee cases that are brought about violations of Title VII, even though they themselves are, for the most part, exempt from having such complaints brought against them. Congress could create an inspector general for federal judges, unlikely in the current climate. It could also draft legislation that might give law clerks and other employees in the federal courts more protection. Recently introduced, but again, unlikely to be made law now, is the Judicial Integrity Act. It would expand to the judicial branch the criminal conflict of interest statute, which currently prevents the executive branch employees from acting with a conflict of interest, and extend that to the judicial branch. I now want to hand off to Heather Shannon, who will address the problems and suggested reforms of the Supreme Court.
Thank you, Sue. Current problems with SCOTUS and suggested reforms. Deem the highest court in the land is empowered by Article 3, Section 1 of the U.S. Constitution. Current problems within the Supreme Court of the United States, SCOTUS, spiked in March 2016 when Justice Antonin Scalia died during President Barack Obama's final year of his second term. At the time, GOP Senate Majority Leader Mitch McConnell quickly blocked hearings for Merrick Garland, Obama's third SCOTUS nominee, saying no nominations would be taken up in an election year. President Donald Trump made his third nomination to the court 6 weeks before the 2020 presidential election, following the death of Justice Ruth Bader Ginsburg and with a GOP Senate in place. In Amy Coney Barrett's fast appointment, the gamesmanship of the Senate brought fresh calls for court reform. This was not the first time in recent history that a politicized nomination took place. Rather, President Ronald Reagan's nominee, Robert Bork, a critic of Roe v. Wade, was the first, and since then, when a nominee is under unfair attack, they're said to be borked. While Article 2, Section 2 of the Constitution serves as a check on presidential power and gives the U.S. Senate vetting muscle over SCOTUS nominees, no Senate rule states when nominations to the court may be taken up. Since 1900, there have been 14 election year appointments. In addition to the SCOTUS reforms presented here, reforms to Senate confirmation rules specifying times during which nominations are made should be considered. Historically, when Senate leadership is controlled by the opposing party to the president, or when there's intra-party division, SCOTUS nominations may be delayed, blocked, or rejected. So despite Garland's block nomination, public approval of SCOTUS held to around 50% for the next 4 years. Reasons for the variation in appointments by presidents to the court include unpredictable vacancies, number of terms served, historic circumstances, and Senate politics. Ronald Reagan named 3 justices, Richard Nixon 4, the most since Dwight Eisenhower's 5, which included the recess appointment for long-serving liberal justice William Brennan. All other recent presidents averaged 2 appointments, though Jimmy Carter made none. With the polarization of the 2020 presidential election and a solid conservative majority seated, reports of ethics violations over lavish gifts and vacations soon skewed the court's public opinion, now at or below 40% and historically low. The erosion of what some call the impartial branch of the federal government happened slowly then all at once, as more power was ceded to the presidency by the legislative and judicial branches, while keeping pace with more complex constitutional issues. The partisan fissures of our nation, as reflected within the Supreme Court, grew deeper at the start of the 21st century with Bush v. Gore, but surged 10 years later over the Citizens United decision, the gutting of the Voting Rights Act, backlash to legalization of same-sex marriage, and the Dobbs decision of 2022, which reversed Roe and 50 years of settled law protecting a woman's right to abortion. As previously stated, the court uses procedural tools, such as the shadow docket, to decide emergency cases, yet with each tool come varying levels of transparency. The shadow docket, in which cases are decided quickly to avoid irreparable harm, often without a signed ruling, came under scrutiny in Trump 1.0 when they were used 3 times more than the 2-term presidents before him. But whether the court issues decisions on merits, shadow, or per curiam, which are unsigned opinions without full argument, as with Bush v. Gore, the public's wish for SCOTUS reform remains high. Given our constitutional understanding of Article 3, Section 1, what can be done to reform the court? Here are 6 possible reforms. Number 1, term limits for justices. Proposal, set 18-year staggered terms for justices, ensuring that each president appoints 2 justices per term. Pros, prevents lifetime appointments, reduces the stakes for each nomination, as well as strategic retirements, promotes regular turnover. Challenges, would require constitutional amendment or creative legislative restructuring. Number 2, ethics and transparency reforms. Proposal, establish an enforceable code of ethics for justices, require financial and gifts disclosures, strengthen recusal rules. Pros, increases public trust and accountability. Challenges, may not fundamentally change court dynamics and poses some threat to judicial independence. Number 3, panel system or rotating justices. Proposal, Justices would rotate between the Supreme Court and lower federal courts, ensuring no single justice serves indefinitely on the High Court. Pros: prevents excessive power concentration, keeps justices engaged in broader judicial work. Challenges: constitutional concerns about how one Supreme Court was envisioned and is structured. Number 4, supermajority requirement for certain rulings. Proposal: requires supermajority, say 6-3 or 7-2, for striking down federal laws. Pros: encourages consensus-based rulings, limits ideological decisions. Challenges: could entrench minority rule. Number 5, public input to the confirmation process. Proposal: introduce public hearing or advisory vote before Senate confirmations to increase congressional accountability regarding advise and consent. Pros: engages public in the process, making justices and the Senate more accountable. Challenges: could further politicize nominations. And number 6, greater transparency of procedural tools such as the shadow docket. Proposal: disclose number of votes and reasoning behind decisions in emergency applications, provide majority and dissent rationales for lower court guidance, remove death penalty cases. Pros: helps clarify legal standards, increases judicial accountability, votes are on record, improves public opinion. Challenges: reveals justice's stance over potentially controversial or polarizing decisions. While none of these reforms is guaranteed to be adopted, some, such as term limits or an enforced code of ethics, have bipartisan interest and may prove more feasible and in line with judicial independence than proposals such as rotating justices. Presently, with the second Trump administration stress testing the Constitution, and with both houses under GOP control, the federal courts are a key safeguard to the rule of law. An immediate test lies with SCOTUS's 9-0 decision in the TikTok case to force a ban or a sale of the Chinese-owned social media platform. The January 2025 ruling was left to the new Trump administration to follow, but as with several lower court rulings, has gone ignored. 1 month in, one question is whether SCOTUS decisions that run counter to the Trump administration will be followed, and if not, will we then be in a constitutional crisis? Back to you, Susan, for your concluding statement.
Thank you, Heather, and to all our presenters tonight, as well as those who have helped us from behind the scenes, creating these slides, handling technology, and doing research. We hope that all of you have benefited from this refresher course on our U.S. federal judicial system. With court cases being brought almost daily at the district court level to address the veritable flood of executive branch orders that impact the lives of our families, neighbors, coworkers, and communities, having a clearer knowledge of the origins and evolution of this third branch of government can help us absorb and digest these rapid-fire news reports. So what's next? For the Denver League of Women Voters, you will have the opportunity to attend consensus discussions to respond to the proposed position statements of the National League of Women Voters. In Denver, we will hold in-person meetings at Montview Presbyterian Church on Thursday, March 27th at 5:30 p.m. and on Saturday, March 29th at 10 a.m. And for those of you who cannot make either of these in-person meetings, we will hold a Zoom discussion on Tuesday, April 1st at 5:30 p.m. Look for links on our website, and please remember, choose only one of these gatherings to discuss our consensus and our decisions. All of the briefing papers created by the League of Women Voters of the U.S. about the federal judicial system will also be on our website. This lists all of the position papers and their topics. They are excellent. I recommend them to anybody who's interested. And these are available to the public as well as to League members. Also on our website within 2 days and open to the public will be a recording of tonight's event, along with the slides and a comprehensive list of the research materials we used. An added slide in case you want to know the difference, between which cases are heard by state courts and which by federal courts will also be available. Please remember, when we began this study, it was before the November election. Tonight, many of us are asking, what can we do now in response to the events that are impacting the daily lives of our neighbors, friends, and families? Please remember that by attending this educational program, you are doing something. Being better informed about our democratic institutions enable us to respond with facts and logic to external forces rather than feel powerless. The Denver League's program committee is planning a briefing on Tuesday, April 15th, in person at 5:30 at Montview Presbyterian, with a panel of experts to look at other opportunities for advocacy and action. And of course, if you're not yet a League member, we invite you to join us in our advocacy efforts to support democracy. I would now like to hand off to Pearl Anzalani, our co-director of communications, who's been monitoring questions in chat, and she'll pose those questions to the presenters. If we get through the questions that have been in chat, we will unmute your audio so that you can ask questions directly of the presenters. Pearl Ann.
Hi, Sue. I think everyone was really clear because there's no questions in the in chat.
So let's just unmute everybody and see
Perfect.
what your comments are, your thoughts, or your questions.
Everyone will have to unmute themselves. I have all muting power, but no unmuting power. So if you want to ask a question, you'll need to unmute yourself.
So this is Patty Cordova, and I was unable to get into the chat for some reason. But I want to thank all the people who put this briefing together because it was excellent. Very, very well done. And I look forward to
Thank you.
To hearing everybody. Yeah, thank you very much, Bobby, Susan, Bob, and who else?
Heather, Bonnie.
Yeah, yes.
Nancy.
I know some of you know that my late husband was a federal judge, and I'm still learning about the federal judicial system. But I think what I wrote down was the reforms and for the Supreme Court. I think the three most likely to occur would be the term limits, which you mentioned had the bipartisan support. But I think the Senate confirmation hearings have become a joke because they're also well prepared and they say they're going to follow the precedents and then they don't. How do you hold them accountable? I don't know. The other reform would be ethics and transparency. And I think that's obvious that we need something done about the ethics. Yeah.
Yes, yes. Thank you, Patty. I agree. And in terms of the Senate hearings, one of the reforms to involve the public could be interesting. It could be a situation where, much like the League, some consensus is developed around questions that are then, presented to senators from the general public.
Yeah, I'm not convinced.
Other comments or questions?
Go ahead, Bonnie.
I was just saying, I'm not sure that we will have better questions than the senators do. I think what we need are better answers that are sort of more truthful and better vetting. I mean, it seems that the American Bar Association evaluations have been not given as much weight as they should have, particularly for appointments to the lower courts, where people that the bar says are not qualified are confirmed and put on the bench. But that's just my whine.
This is Bob. Back in the day, I'm not quite sure when that was, the ABA's assessment of unqualified, qualified, and highly qualified was, if not disqualifying, if it was negative, influential. And usually, simply qualified was not considered adequate in many, many cases. You had to be highly qualified. Now, I don't know what standards they use, but now any old person, I guess, who hasn't, been sued for malpractice and hasn't had complaints by clients can get a qualified rating. I mean, and again, I don't mean to pick on anybody, but this Eileen Cannon in Florida, she had no meaningful trial experience in federal or state courts, and yet she's a federal district court handling consequential cases. It's, and I think she was qualified. Maybe she was highly qualified. I don't know. If she was highly qualified.
Well, you followed it more closely than I have, that's for sure.
Were any of you surprised to hear any of the things that we mentioned?
There were certainly lots of things I didn't know, so which was great to learn them. Sorry, I think I talked over someone.
This is Bonnie Clark. Reading about this, I was really blown away, very deeply and poorly impressed with the random timing of appointments to the Supreme Court, and the fact that it's good luck or bad luck, and I think that if we're going to ever have sort of a consistent rational court that doesn't bob back and forth from one interpretation to another, I think that would make regularizing the schedule would make a big difference.
Some of you may wonder about the proposal that Heather mentioned about an 18-year term limit for Supreme Court judges. And this is a proposal from some very bright people, and it has been made by more than one. That number 18 was selected in part because prior to the appointments, as I understand it, prior to the recent appointments of younger Supreme Court judges and people living a lot longer, the average time that judges were on the Supreme Court was about 15 to 18 years, or maybe a little bit more. And the feeling was that would give Supreme Court justices enough time to get, their feet wet, to really be able to be well educated about the functioning of the Supreme Court. And part of that proposal would also be to create emeritus roles for justices who completed the 18 years to continue on as justices, not on the regular 9-court panel, but where there was necessity to have extra judges. For example, if someone recused himself or herself, that an emeritus judge could step in to fill the full number of justices. So you can read more about that. I think we have references to that in our list of references, but it's a very interesting approach. Again, sadly, right now, probably not one that's going to be taken up by the Congress, but it is an interesting proposal that I think really could make a big difference. Other comments?
I have a comment. I have a couple of things. I'm wondering, one of the more discouraging pieces of information to come out of this study was the lack of enforcement that the Supreme Court has. Our government is based on checks and balances, but there is really no way that the Supreme Court rulings can be enforced. And that was highlighted by Bob's report about the Brown versus Board of Education in 1954, and how nobody really could get anything accomplished. The other one, I was thinking about one of the reforms that you were talking about, Heather, and that is having more members on the court that could serve. Some could be senior judges, and then they could go to a lower court and they could circulate a little bit more. But you mentioned that one of the challenges was a definition of one Supreme Court. Did you read very much about controversy about that definition? Because were they thinking that the Supreme Court has to be, all intact? Just enlarging it doesn't make it less than one in my mind, but I just wondered if you encountered some information on that.
Yeah, Jeanette, the one Supreme Court idea is basically there is only one Supreme Court, and they hold the ultimate judicial authority. Congress can establish lower courts, but not additional Supreme Courts. And the court ensures legal uniformity and is sort of the final interpreter, arbiter of the Constitution. Did I answer your question? And I'm not a legal authority. Bob, maybe you'd like to
Yeah, I'm not quite. Yeah, I'm
take
not
a
quite
pass
sure.
at this.
Yeah, I'm not quite sure what the question is. I think it's well within the power of Congress to increase the number of justices on the Supreme Court. And I think it's well within their power to term limit them so long as once they're term limited, and if they refuse to retire, they can continue to serve as a justice sitting in circuit courts. And in fact, Justice Souter, I don't know if he's still doing that. Justice O'Connor resigned, even though she was still, relatively young, because her husband was very ill, but she continued to sit on circuit courts. So I think you don't run afoul of the lifetime appointments provision, which, as Sue said, is a matter of construction, not a matter of literal meaning. By giving them, keeping them, and what the Article 3, Section 1 says is, they serve as long as there's good behavior and you can't diminish their pay. So keep paying them what they were getting and send them out to senior judge duty. They
And
do
that's
that.
what happens at the lower courts.
Yeah, they do that in federal district courts. They do that in circuit courts. And as I said, I don't know whether they're still doing it. Souter and O'Connor did that after they retired.
For those who want to explore the pros and cons in more depth, the commission that Biden appointed created a report on the Supreme Court specifically, and it was criticized for not really having recommendations. It's very good in terms of this side argues this way and the other side argues that way. So, and you can't find it at the White House anymore, but you can find it on a website called Ballotpedia. So if you just search for Biden Supreme Court report on Ballotpedia, it will come up. It's long, but you can kind of pick and choose what you read. And it certainly does summarize what all the various witnesses had to say on quite a number of these proposed reforms. And I think it didn't make our list, so that's why I'm promoting it now.
Well, let me just chime in one more time, Jeanette. In terms of enforceability, that is a real question because, as Heather said, the Supreme Court said unequivocally, TikTok had to be sold by a date certain, and the decision did not qualify it. And what happened? Trump came in and he ignored it, and we're still drifting along. And the USAID case, the lower court said, you have to, I told you once, now I'm telling you again, you have to fund that foreign aid. And he ignored it. I mean, now he has a stay from the Supreme Court. But I think there's a serious issue looming out there about whether this administration will obey court decisions. And in fact, J.D. Vance has said, let them enforce it. So, I mean, that's a really serious issue.
It's very, very scary.
Yeah. And the one other issue, and I'm sorry to come in here, that I didn't mention, but is in conjunction with some of this stuff, the shadow docket and whatnot, is there's a theory called the unitary executive. And this dates back to the Reagan era and was basically, as I understand it, cobbled together by the Reagan Justice Department and the Federalist Society. And it has been put forward and put forward and put forward, and basically says the executive can kind of do what it wants because they have absolute authority when it comes to the executive department. And the Supreme Court has come very close. I cite a case in the short history. I cite a case there that where they essentially said, the president has absolute, the executive has absolute authority. And if you compound that with the immunity decision, which says he can do whatever he wants in his core functions and pretty much what he wants in his job functions, you're looking at an omnipotent executive who's likely to disregard court decisions.
So when you put the bad decisions together with the unfortunate reluctance to disclose ethical and financial situations, this is not surprising that the public's opinion of the Supreme Court is way down, but with that low opinion, that probably makes it still harder for them to enforce judgments against the executive should they really feel it's important.
I agree.
They don't have moral authority.
Right.
I was
The
surprised,
issue, go
I
ahead.
was surprised to learn that the Federalist Society was created in 1982.
Yes.
And
Oh,
think of
yeah,
the
it's been
power-
around for a long time.
Well,
Mhm.
I was thinking it's not so long as the League. And they have great power. It's fairly young. So yeah.
Well, Ed Meese, who was the first attorney general under Reagan, was, I think when he was attorney general, was one of the founding members of the Federalist Society. And you now see almost every single appointment by Trump to a federal judgeship is a member of the Federalist Society. And
the Federalist Society starts to work with law students when they are in law school and begins to really develop a pipeline of encouraging law students in all across the country who have more conservative leanings to participate in the Federalist Society. It's a long view that was taken by, as Bob said, or Heather said, after the Bork decision, when Bork was excluded from being a Supreme Court justice
Not confirmed.
because of his conservative leanings, and they didn't want to see that happen again. All of us except Bob are non-lawyers. And as each of us, I think, read more and more and more, some of us have had, like Bonnie, have had involvement in the court systems. But part of what I think was wonderful about serving on this committee is the increase in certainly my knowledge. I don't come from I'm partnered with Bob, so I typed his papers in law school, but I don't come from a legal background. And it was wonderful to really learn and expand my knowledge and my understanding of such an important branch of our government. And I think it has made me certainly a better League of Women Voters member, having more knowledge under my belt, plus a lot more questions and a lot more concerns.
Yeah.
But, civics education has really diminished in high schools. And there is a task force that the State League has to encourage and find ways to support civic education among our youth. And of course, as they reach the age of 18, they become voters. And voters who don't have any background in civics and an understanding of the underpinnings of democracy are a problem. Bonnie, you keep holding up your hand. What do you have to add?
I just wanted to remind all the leaguers that we're doing a national consensus on this. And although I don't have much hope that there will be any reforms that will be passing through our national legislature in the near term, I think it's really important that we do have the ability to weigh in when something good comes along in the future. And I do remain hopeful that that will happen as time passes, that public pressure will motivate folks to look seriously at the way this system operates and see if we can't make it better.
I have a question. It's Marty.
Go ahead, Marty.
Really thinking about what Bonnie just said. I mean, I had already been thinking this, but I don't see much hope for these reforms short term. And yet we know that you have to start somewhere and work and work and work and work to get something passed that is against the grain at some point in history. But I was just thinking of short term, just electing reasonable people to Congress. I don't know, it's just been such a shock to me that that the power struggle is more important than any kind of reasonable thought. So I think that's the first thing we can do, is try to turn things around in 2 years and see if we can make a little progress and see where we are. But learning about these reforms is very important, because we need to start somewhere. So I appreciate everything that the committee did. I'm very anxious to see the information from national. I have not looked at that yet. But when I looked at that quick list that you put on the list, it looked like you all have covered most of that. So that's great. So that will be very helpful. Thank you.
I don't know if any of the people still here in the Zoom are not league members. Please note, Bob Connolly is a man. Frank Bennett is a man. League of Women Voters does accept males into its ranks, and we encourage men to join League. And certainly, if, as I said, if some of you most of the names are familiar to me, so I think most of the people that are still in the Zoom are League members. But we really like to have more people coming into League and joining League. These are some of our upcoming events. Thank you, Pearl Ann. We have what we call our Socially Aware Book Club. And the book that we've chosen is Circe, which is a really interesting book. I'm reading it right now. We will have the consensus discussions at the end of March and April 1st. And on Tuesday, April 15th, opportunities for advocacy and action, which will be held in person at Montview. So, and that certainly is open to the general public. The consensus discussions are for League members only, but you can join the League after this meeting if you haven't joined before and be part of that consensus. I'm mindful of the time and seeing that it's just about 7 o'clock. I know that we have competing things on the TV that some of you might want to go subject yourselves to. But I really appreciate those of you who hung in there with us and listened to this presentation. I want to again thank this incredibly hardworking study group. We put in dozens of hours creating this program. Thank you very much. Take care, everyone. I'm glad I don't have to say get home safely because you're all at home already. And hope to see you at future League briefings and certainly at the consensus meetings. Good night, all.
Thank you, Sue. Good night.